Welcome to datascience.show, the podcast where data science meets executive leadership. We talk with top AI and analytics thought leaders about turning data into real business impact. If you're a C-level leader or data expert shaping the future, you're in the right place.
Let me start with a short story, anonymized, but every detail matters. A large retailer rolled out a new recommendation engine. For weeks, the model improved engagement and revenue. Then, one pricing anomaly slipped through. An update changed how discounts applied to bundled products. Overnight, several thousand orders were processed at incorrect prices. Customers noticed. Complaints spiked. A competitor's lawyer filed a demand letter. Within days, the board was on calls. The company faced potential class action exposure and regulatory inquiries. What could have been a contained incident became a weeks-long crisis because the executive team hadn't prepared the legal and operational playbook in advance. That vulnerability turned an engineering bug into a corporate emergency.
If you're listening as a CEO, GC, CDO, or CRO, ask yourself, do you treat litigation readiness as a budgeted, board-level insurance line item, or as a PR problem you'll improvise when the press calls? Today, I'm giving you a compact, decision-first playbook. This is not legal advice. It's an operational and governance framework you can take to counsel, procurement, and the board. The goal is simple. Convert surprise litigation into managed, fundable choices so you preserve reputation, optionality, and balance sheet predictability.
First, how do incidents trigger the legal war room? You should codify a short list of escalation triggers that automatically prompt counsel and leadership. Think in 3 buckets: customer signal spikes, sustained complaint rate above a threshold, or a high-severity complaint type, like safety or discrimination; monetary anomalies, a sudden deviation in transactional dollars beyond X standard deviations, or a systemic pricing error; and external contact, any regulator outreach, third-party demand letter, or media escalation. Add a human speed trigger too. If legal or product leaders say, "We're unsure about liability," that by itself is a trigger. The point is simple. Detection to escalation latency kills options. Shorten that path.
Next, preserving privilege and evidence. Who you call first matters. Step 1 is counsel, internal or external, with litigation experience in your jurisdiction. Ask counsel to issue a legal hold immediately and to advise on communication channels. Then lock communications. Move the conversation to counsel-approved, access-controlled threads. From an engineering perspective, implement tamper-evident evidence capture, immutable timestamps, signed manifests of data snapshots, narrow forensic exports of model inputs-outputs, and full logging of system changes with human approvals. Package those artifacts into a confidential evidence pack for counsel, labels, providence, chain of custody notes. And be deliberate about privilege. Do not CC broad teams or post sensitive threads in public chat. Privilege evaporates through carelessness.
Vendor and contract triage is quick triage you can run in the first 24-72 hours. Use a short rubric. First, what indemnities apply? Second, do you have audit rights or source access to reproduce the failure? Third, is there reliability cap or a carve-out for deliberate misconduct? Fourth, what are vendor notification obligations? Do they require notice within X days? Based on that rubric, classify vendors as immediate partners, must cooperate now, constrained partners, partial assistance, likely negotiation, and non-cooperative, plan for independent remediation. Preserve procurement records and pull the signed contract PDFs into your evidence pack. Those clauses often determine whether the vendor is a source of defense funding or additional exposure.
Now, insurance, funding, and decision gates. Claim your insurance early. Notify carriers under the policies that may respond, but do this in counsel's guidance so you don't waive privilege inadvertently. Establish an escrowed remediation fund or a pre-authorized reserve line. This is the board-level insurance I mentioned. Set explicit decision gates. Beneath a threshold X dollars or Y customers affected, remediation can proceed operationally with C-level sign-off. Above that threshold, you trigger board review and a counsel-led settlement assessment. Define settlement versus remediation criteria up front. Remediation if it restores service and limits harm quickly. Settlement if the reputational and ongoing legal risk exceeds remediation costs, or if remediation will cause greater customer disruption. Make these financial gates explicit so the CFO and GC can act without hour-long debates.
Communications and regulator coordination must be coordinated, not ad hoc. Your counsel should draft a short comms playbook: who speaks externally, approved messaging tiers for customers, regulators, and press, and a timeline for disclosure. For regulators, acknowledge contact, state that you're investigating, and commit to a timeline for follow-up. For customers, offer transparent remediation options tied to the harm, refunds, credit, or remediation steps. Keep the tone empathetic and practical. Over-defensiveness looks like evasion, which invites enforcement. And always align public statements to what you've preserved as evidence. Consistency reduces downstream exposure.
Here's a prioritized 30 to 90-day readiness checklist you can act on this quarter. 30 days. Stand up a legal war room template. Identify your litigation counsel and escalation contacts. Inventory the top 5 products by exposure and run one tabletop with engineering, product, legal, and comms. 60 days. Implement tamper evidence snapshot processes for those top products. Secure or revise key procurement clauses for new vendors, and negotiate pre-approval lines for remediation funding. 90 days. Expand the evidence preservation pipeline to additional products. Run a full-scale rehearsal including insurers, and present board-ready KPIs and decision gates. Start small. Pilot one high-exposure product. Measure gaps, iterate, then scale.
What do you report to the board? Keep it concise and metric-driven. 4 KPIs matter: exposure runway, estimated worst-case financial exposure and the funding runway you have; detection to legal lifecycle latency, how long from signal to counsel engagement; evidence completeness score, percentage of required artifacts that meet your chain of custody standard; and vendor cooperation index, are your top vendors providing necessary access and indemnity. Assign an owner for each KPI and include them in the quarterly risk dashboard. Boards want clear options and known trade-offs, not ambiguity.
Before we close, 3 executive actions you can take this week. 1. Put a legal hold and escalation trigger into your incident response playbook and run a 90-minute tabletop with counsel and infra. 2. Designate an escrowed remediation fund or pre-authorize a remediation credit line with the CFO. 3. Inventory top vendor contracts for indemnity and audit access. Start with the 3 vendors that handle customer decisions. Do these 3 things and you've moved from reactive to prepared. That's the difference between models and value. Subscribe to datascience.show to get more executive playbooks like this. If you found this useful, bring it to your GC and run the first tabletop this month. Grounded, practical steps win.
Thanks for listening to datascience.show. If you found value in this episode, subscribe, share it with your network, and join us next time as we explore how data science drives smarter decisions and better business outcomes.